Hi, everybody. Hello. How was break?
Good. Short.
Too short. Well, any consolation, we don't have class Thursday. Like, catch up, whatever. And today ought to be pretty easy. All we're going to do today, as we did before when we had a group of cases, we'll just go through from, you go through Alona, I believe, and then you come back next Tuesday and there's another small group of adoption cases after that. And then we'll get into some fun stuff too with a mock hearing that we're going to do, and I'll give you the facts for that probably next week. A little bit tricky, not issue, but in terms of trying to understand all of this, that even though I separated out and we talked about care and protection cases, and now you have a group of adoption cases, what called adoption cases, many of these cases were nothing more than care and protection cases in which the department changed its goal from originally reunification, offer services because parents are unfit, to changing the goal to termination and adoption. And another thing that might also confuse you as well is some of the cases are old, and they may be old, but they're not overruled per se. But they may be cases before the statute was changed to allow the juvenile court to terminate parental rights. So keep that in mind. For example, some of the older cases, adoption of Paula, for example. No, actually 95. Yeah, adoption of Paula may have started out that way. Adoption of Diane, which is 1987. Those cases may have started as care and protection in juvenile court, and when the department changed its goal, the department had to go, because that was the procedure back then, to probate court to file a petition under Chapter 210, Section 3 to dispense with parental consent to adoption. Now, post 94, okay, if a case was started in the juvenile court, a care and protection case, in which at some point the department changed goal to termination, it doesn't have to go to probate court anymore. It remains in the juvenile court in the context of the care and protection case. The care and protection case is just sort of, for lack of a better word, broadened, so that the juvenile court judge can not only decide whether to adjudicate children in need of care and protection because parent is currently unfit, but also to take a look at whether parents' consent to adoption should be dispensed with because of all those, the factors in 210 Section 3. So keep that in mind as we go through some of these cases. Laura?
Why, in some of the cases, they do temporary and then permanent custody to the department and then adoption? Mm-hmm. Why would you do permanent? Like, what does permanent get you versus adoption?
Good question. Anybody can answer that? What is permanent? What's the difference between permanent custody, say to DCF, versus adoption? Jim?
I could be wrong on this, but I think that under DCS still has custody of the child. The parent may still be able to retain custody, but if they're adopted, the parent has lost all their...
Parent has lost. It's a legal, think of it as legal separation. No more parental rights. Whereas permanent custody, as Jim just said, custody to DCF. DCF is the custodian. Parent has not lost parental rights. And remember that there are options for review in the juvenile court. You go to trial in a care and protection case, as you know, and you represent mom or dad or child for that matter, and department as well. Case goes to trial, department gets what's called permanent custody, as Laura just said. The case itself in the juvenile court still remains open. In other words, it doesn't get dismissed. It remains open for a number of things. One is, after a year, the parties come back for what's called an annual review. And that's under 119-29B. Another option is, say, 6 months later, mother, father, child can petition what's called a review and redetermination. And it's still, it's in juvenile court, and any number of, say, changed circumstances. I went to alcohol counseling, I'm no longer an unfit parent, I want the court to look at my case again. Whereas if the court, after the trial, went the next step and dispensed with the parent's consent to adoption, parental rights are terminated. What's the only option you have if you represent the parent? I lost my parental rights. Is there anything you can do after that trial?
Yes. Appeal.
Appeal, that's it. So nothing further in the courts, in the trial court system. You can appeal for an error of law, abuse of discretion, etc. And that's what some of these adoption cases are that you read for today. So let's start with Hugo, and I'll just go around if you want to volunteer, whoever wants to start with Hugo. You want to? Okay.
DSS.
Who's DSS, by the way?
The Department of Social Services.
So how is that different from DCF? What's DCF stand for?
Department of the Children and Family.
Yeah. So what's the difference?
I'm not.
Anybody?
I'm not exactly sure.
What's the difference?
Aren't they basically the same?
Yeah, no difference. A couple of years ago, the statute changed, and yeah, same agency. Yeah, trick question. Before, some really old cases, and I think I took some of the older cases out of the CD. You may see sometimes a Department of Welfare. Department of Welfare, which was this sort of a bigger umbrella agency before DSS had started. Okay, Joe.
Well, the DSS had proposed that Hugo, who was 4 at the time, be adopted by his foster mother, who he lived with from the age of 2. Hugo had been in, I was going to say he'd been in the care of DSS from 3 days old. They received temporary custody, and that's when he went into a foster home. And then about a little bit less than a year later, DSS wanted to dispense with the parents'
Consent to adoption,
to
yeah.
the adoption. And so then a hearing on the merits was held in October, and the judge adjudicated Hugo was in need of parent protection, and he was committed to permanent custody of DSS.
What did the court decide about adoption? Placement?
Well, DSS had a plan for Hugo to be adopted by his first foster mother.
Yep.
And so
But,
oh, go ahead.
no, I said, but, what happened?
Well, the parties came together and decided to set aside that first adjudication in the juvenile court, and they decided that they wanted to have it heard by another judge, and that separate counsel be appointed for the parents.
I just lost you in that last.
Well, there was an appeal.
Wait, before the appeal, who else is in the picture besides the foster mother in terms of adopting Hugo? So you said DSS said, we had custody all along, we placed with this foster mother, she's great, Hugo has special needs, blah, blah, blah. Who else is in the picture in terms of potential for adoption?
Was it the
His aunt.
paternal aunt?
Yes,
Mrs. J?
yeah. So isn't that what this case is really all about?
Yeah, it's Mrs.
So what happened with the aunt?
Well, the aunt was better suited.
Why? The aunt didn't even know the kid. The aunt was in New Jersey, right?
Well, the aunt had an independent source of income besides being just a foster parent. She had raised her own child with special needs. I believe her husband had a stable job as well, and there weren't going to be. It was more stable because that's what Hugo needed because he was very. I wouldn't say. I mean, I guess he had been traumatized.
So you had said before that Hugo was placed with this pre-adoptive foster home from when he was a baby till
So he had
trial. So
right. So
a
he
good
had,
number of years, right?
So he had developed a connection with Mrs. L.
Mm-hmm.
And so the whole case pretty much came down to the cost-benefit analysis of, yes, it might be costly to take him away from Mrs. L because in the short term, because it's going to be hurtful and it might be a tough transitional period. But in the long run, his aunt, Mrs. J, would be better because the benefit would be more with Mrs. J because with Mrs. J, she has the history of raising a child with special needs. She has the stability of the income. There aren't going to be foster kids in and out. And so that's essentially what the case came down to in the long run, down the road.
Why does the SJC call it a heart-wrenching decision?
Well, because, like I said, Hugo had developed a relationship with Mrs.
Isn't that one of the factors, the 14 factors that Chapter 210, Section 3, that the court looks at in determining best interest in terms of adoption? The bond with the...
Yes, that's one of them.
So why wasn't that an abuse of discretion on the part of the juvenile court judge?
Because
Did the judge just ignore, the fact that the child had formed this huge bond with the...
No, because the judge had made specific and detailed findings, and he demonstrated that he paid close attention to the evidence, and he used his discretion in a proper manner, and he took the best interests of Hugo into account first and foremost, and in the long run, Hugo was better suited with Mrs. J because, like I said, of her history, her stability, and the solid income as well.
And you're absolutely right when you use the word discretion. So the SJC, is talking about how the SJC or the appeals court reviews, what the lower court, what the juvenile court judge, has done below. Makes it a point to say, we're not sitting as a second judge now to review the case, what's called de novo, and make our determination as what we think is best for Hugo. It's the appellate court looking down at what the judge below, who got to hear the evidence, observe the demeanor of the witnesses, reviewed everything, whether the judge below has abused his or her discretion in determining that it was in the best interest of a particular child to, not only be freed up for adoption, but to be, placed and adopted by a particular family. So the adoption part of the trial, you notice, is kind of in two pieces, right? Well, there's three pieces. There's the determination of unfitness, right, of the parent. Then there's whether that unfitness, do you take it a step further, whether that unfitness warrants that it's in the best interest of this child or these children that parental right be terminated, and then finally looking at who, if and that's not always the case. You might have a termination trial without prospective adoptive parents. The kids might be just in foster care, not in pre-adoptive. But in this case, that wasn't the case. The foster mother had been already approved by DSS for adoption.
That just puts the
So-
child as open adoption available, like ready and able to be adopted, right? If they seek to disperse with the consent.
Yes,
You know.
yes. And remember before when we talked about DCF's duties and we talked about service plans? So service plans, there isn't just one at the very beginning after investigation. There's going to, you know, so if a kid is in, say, in DCF custody for a number of years, every 6 months or so, the DCF gets together and comes up with, you know, a new service plan, reviews it and so forth. So the service plan could be changing from, you know, a period of time to the next period of time, et cetera. And consequently, children can also be moved, you know, department, you know, has custody. And remember the custody, section 21, the definitional section, the right to determine the place of abode. So they could, you know, so say DCF does change, say, you know what, these parents are always going to be unfit. We have to, you know, make some plans for these children. So they could be in a foster home that's just a temporary foster home that just has, you know, the contractual agreement, blah, blah, blah. But then there are different foster homes that also have been approved for adoption, you know, parents that are not only looking to foster kids, but want to actually adopt. And that's probably, you know, what, now Mrs., what was the foster mom's name in the
L.
case?
Mrs. L.
Mrs. L may have been, I'm not sure, was she from the beginning pre-adoptive designated as?
I believe so.
I believe so too. And as the SJC says, really heart-wrenching decision because, you know, but for the aunt who not only has the biological connection, even though she really doesn't know the kid, right? But also has, according to the juvenile court judge, you know, the ability to care for Hugo's best
It
interests.
says track record,
Yep.
talent, capability, and desire.
Yeah. But can you just imagine the scene, right?
Yeah.
When Hugo was taken out of Mrs. L's, not only to go, you know, 30 miles down the road, but to another state. So when I asked you the question before, heart-wrenching, and a lot of these cases are like that.
It's tough sometimes reading these cases because we don't have all of the background information.
Exactly.
But you sit there
Exactly.
wondering, like, where was this aunt from the beginning?
Exactly, exactly.
Yeah.
And was it like a case of DCF's abuse of discretion? You know, did she from the beginning ask, and then DCF didn't properly do the, what's it called, the interstate compact? You know, that's a whole other thing where they're supposed to approve and get them over to the agency over there. Who knows? Yeah, you're right. Who knows whether she wanted to be involved from the beginning and wasn't because of somebody's, you know, error or abuse of discretion. But
So then,
yeah.
So then that last argument that is made by DSS, you think that there was a decision made on inappropriate factors such as material opportunities
Right, right.
that she may be able to offer that maybe Mrs. L couldn't have, but
Yes.
you know, it is a big disruption in Hugo's life, you know, for maybe not that much of a benefit down the road.
Whenever you have situation where there are biological relatives around, DCF really has to be careful to make sure, you know, that I guess to overrule any chance that there could be an option out there. You know, and of course, they have to also be like the aunt here, ready, willing, able, competent to take care of this child.
I don't,
Yeah.
my personal experience that if anything had ever happened to one side of my family, that if I ever had to go to the other side of the family, I would have just preferred to have a foster family, you know? like, I know they're my blood, but you know what I'm saying? It's like, I'd rather be someplace else in my personal.
Yeah.
And I know they take that into account,
Yeah.
but at the same time, you know, biologically, you know, related doesn't mean much to an individual cases sometimes.
Exactly. All right, thank you, Joe. Eno v. LLM.
I'll do this one.
Okay, Amanda.
So this was a lesbian relationship where the defendant was artificially inseminated and became pregnant, and the plaintiff was essentially a de facto parent for the child.
Okay,
Before-
when you say essentially, that's what the SJC ultimately determines.
Correct.
So tell us about the relationship of that parent with the child.
So the child called her mummy,
Okay.
called the other mother mama, was very attached, provided financial stability for the family, was always there as if, like, was always there like a father would have been in this situation. I think that the plaintiff had some problems after the pregnancy and assumed primary care of the child because of the medical problems. Before they even got artificially inseminated, they came up with an agreement on visitation, and this is why they brought it to court, because the parties ended up splitting, and I'm just getting mixed up because there's not names, and the non-birth mother wanted the agreement to be set in place so that she could still remain to see the child. You could tell that there was a clear attachment from the child to the parent,
Okay.
and the child is entitled to be protected from the trauma caused by the disruption of the relationship by the plaintiff, meaning that even though the birth mother and the birth mother decided to separate the other mother, that not allowing mommy to see the child could essentially hurt and traumatize the child. And that's why they set forth, just so that they could come up with an agreement to have some type of visitation.
Okay. So Amanda, this was a not abuse and neglect case.
No.
Not an adoption case.
No.
But seminal case that in Massachusetts defined the de facto parent.
Yeah.
So how would you use it, say today, in a CMP?
A de facto parent?
Yeah. So how would you make an argument to a juvenile court judge that someone has certain rights, even though they're not the biological parent? So what are the parameters? What are the factors that define someone as a de facto parent?
De facto parent is one who has no biological relation to the child,
Yeah.
but has participated in the child's life as a member of the child's family.
Keep going.
The de facto parent resides with the child and, with the consent and encouragement of the legal parent, performs and shares in the caretaking. And the caretaking functions at least grade. The de facto parent shapes the child's daily routine, addresses his developmental
I'm
needs.
sorry not to interrupt you, but who could be a de facto parent? Can you think of an example of?
Could be an aunt, an uncle.
Okay, so if an aunt is a de facto parent, how define or give me some facts that would
Would qualify?
qualify, say, her.
Okay,
So there's a
there
kid.
for the child, feeding, clothing, anything, doing laundry, giving rides, anything having to do with school, medical needs, actively participating in the child's life, I guess would be my argument.
Okay. What about anybody else? Michael?
How about a boyfriend or a girlfriend of the parent?
Mhm.
So it's not their
Could be.
child, but,
Mhm.
you know,
Has lived in the
they've been
home, has
caring
been
for
a
the
partner
child,
to the other.
supporting the child,
Mhm.
you know, set their bedtimes and things like that.
Mhm. Laura?
A guardian?
A guardian.
Yeah.
What do you mean by that?
Well, if a child's not living with their parents, per se, they could live with a guardian or a foster parent, and they would fall under de these factors.
Well, you said guardian or foster parent, two really different legal terms, right?
Yeah. But
Could a foster parent be a de facto parent? And really think about that for a minute, in terms of what a foster parent is. So, Amanda just said, and I think I have some of it here, no biological relationship to the child, participate in the child's life as a member of the child's family, resides with the child, as Michael said, caretaking functions, shapes the child's daily routine, blah, blah, blah. Does a foster parent fit within the scope and definition of de facto parent?
I think the only thing that would be questionable is with the consent and encouragement of the legal parent, because sometimes the children are removed from the legal parent.
What else would make a foster parent not fit in this definition? Joe?
Well, I was thinking because they are the legal parent, so.
Because who's the legal
foster
parent?
parent is.
No, they're not. What's a foster parent? Again, a foster
Oh,
parent.
I was thinking adoption.
Okay. You're thinking of the adopted parent.
Is it the part about participating in the child's life as a member of the child's family? So
Member of the child's family, aunt, grandmother, sister. Okay, think of relations like that. Guardian, I didn't want to address that because that takes you into another sort of, guardianship. You have other rights as a guardian. But cases where someone would come up and say, you know what, I have these visitation rights because I've been taking care of the kid on a daily basis, even though I'm not the kid's mother or father. And that's all it is. And that this case is, decided way back in 1999, but cited today for the argument. And you may see sometimes, and that's frequently it, usually a grandparent sometimes, or, aunt, like you said, somebody that's very close that says, I want to be recognized by this court as a de facto parent. Who wants to do the adoption of Iris case?
I'll do it.
Okay.
The case from 1998 out of the Supreme Judicial Court. In 1993, Iris was 1 month old when she suffered a skull fracture causing hemorrhaging to her brain. And it was the cause of the injury was never fully explained. DSS filed a care and protection petition on behalf of Iris. And then DSS assumed temporary legal custody, and she was placed in a foster home where she presently remains when this case was adjudicated. The parents were not able to offer an explanation for the injury. They did, however, cooperate with DSS numerous demands, including a psychological eval, individual counseling, and they would visit Iris at every possible opportunity. In May of '96, there was a 3-day trial where the judge adjudicated Iris to be in need of care and protection and dispensed with the parents' rights to consent to her adoption. And the parents appealed, and the appeals court vacated judgment and remanded to juvenile court for further proceedings. Then the appeals court concluded that the judge's findings on the unexplained injury were regrettably sparse and failed to show.
Well, what? The judge's findings on the injury?
They said they were regrettably sparse.
Yeah.
And failed to show clear and convincing evidence that the parents were unfit. And the appeals court directed the juvenile court judge to determine whether the department goals remain the termination of the parental right, and whether the department had sufficient additional evidence to warrant a new trial. And if they did, then they'd order a new trial forthwith. Ironically enough, the same district court judge for the trial had the hearing, and DSS stated that they had continued intentions both to pursue dispensing with the parents' rights and also to place Iris for adoption with her current parent. And then DSS had additional evidence which was not brought up at the first trial.
Additional evidence of what?
Let's see.
Related to what? Because you had just said earlier. that the evidence of her injury was sparse, I think I heard you say?
Right, the new evidence would include expert testimony from physicians at Children's Hospital that examined and treated her, and testimony of all others who had interactions with Iris during those several days preceding the injury,
Yeah.
and testimony of professionals who currently provide services to children. And this additional evidence would help clarify how the injury most likely occurred,
Okay,
and whether either parent had injured the child or knew who had, whether
Okay.
either parent knew had prior knowledge before taking the child to the Children's Hospital and that she had serious injury.
so it's all the new trial stuff.
Correct.
Okay,
So their first argument, the parents filed a petition, and they have several arguments. The first argument they had was care protection and termination violated this substantive constitutional rights to be free from double jeopardy.
double jeopardy, exactly. So what were they saying relative to double jeopardy? What was their argument? So
They
it was
raised
trial-
it from the double jeopardy issue for the first time on appeal and cite no authority as they didn't have any authority to support their claim, but they were citing it from the first time on appeal, saying that the matter had already been addressed. So
What is double jeopardy?
double jeopardy is when you're retried for something that you've already been adjudicated.
That's already been adjudication. So parents were essentially saying, you had trial number one. One of the issues was the injury of our child, right? And there were holes there. There wasn't, enough evidence of the brain injury or whatever, I forget what the child exactly had, right? And then you're going to have trial number two, when trial number one already took care of that issue. So you're imposing upon me, right, being tried again. But what does the SJC say about that?
The court stated that it had previously rejected the claim of double jeopardy applying to care and protection proceedings.
Exactly, why?
Initiated, because they're not criminal in nature, and according they don't have the, I forget the word,
Yeah,
but they
you
don't
got
have
it.
the constitutional rights afforded to criminal defendants, so it wouldn't apply in those cases.
And I don't remember if the quote came from this case or one of the other cases that you guys read, the full panoply. If you
Yes,
see here,
it's in there.
the full panoply of constitutional rights afforded criminal defendants do not apply in these cases. But here's where it gets tricky. We just completed the child sexual abuse case with Lee, who was, because of the care and protection case, because what's going on in the criminal case, there are implications in the care and protection case as well. And the question becomes, well, am I not somehow going to be held criminally responsible for, the alleged abuse and neglect in the case that's supposedly not criminal? But anyway, the case was decided by the SJC. Double jeopardy doesn't. So that's the law so far. Does not apply in care and protection cases.
I'm pretty sure it wasn't from this case. I think it was from either another case we read or one we've read previously. But didn't they also say at one point too that these care and protection cases, they're not really a final adjudication, that because there's sort of a continuing process and these 6-month revisits?
Yeah, but although this one became a termination case. So, but you're right. Termination cases are, different from the example that you just gave. But good point, yeah. Anything else you want to say, Jim, about?
And what they did say, which I thought was interesting, is that any retrials are not aimed at punishing the parents, but rather at protecting the child. That's
Right. The statute normatively named is care and protection, right? It's all about the care and protection of children. Who wants to do the Paula case? Laura?
So, 1995 case out of the SJC. Before I get into the text, so Paula was the mother's daughter. Then the mother married a man, and they had 5 siblings right away. So, in 1991, there was a care and protection file for Paula and her 5 sisters. In 1993, the probate court dispensed with the parental consent to adoption. Both parents appealed, and the SJC granted direct appellate review, and they affirmed. The parents on appeal brought up 3 major issues. The first was the use of the care and protection findings for the hearing regarding the dispense of
Right.
adoption.
The use of the care and protection in the adoption trial.
Yeah. So they are supposed to be separate sets of evidence, but in this case, the findings from the care and protection proceeding were repetitive of other properly admitted evidence, and the SJC said there was no prejudicial error arising from their admission. The second on appeal was the father's fitness, and he questioned 3 parts of the evidence. And the first was the court-appointed investigator. He said that that was hearsay. And so the SJC clarifies that when you have the opportunity to refute the investigator and
Right.
the investigator's sources through cross-examination and other means, the admissibility of the report and testimony are fine. That's also true for a GAL. They just briefly said that the admission of the police report as a business record was proper, and that information from the father's current circumstances came primarily from his own testimony. So they took that off the table, and then most of this was about the evidence of the mother's current unfitness.
Right.
She had left the girls, she had left a couple of times, and then she left permanently. And when she was gone...
When you say left, what do you mean?
Left, the father left the girls with the husband's, in that home with the husband and his 2 prior children.
Okay, and why did mother do that?
Because of the violence from the father.
Exactly.
And so she claimed battered woman syndrome. What happened though when the girls were left there was that his older children, the care of the Paula and the 5 sisters were left to his older children, and 2 of the older girls were eventually sexually abused by the boy.
Yeah.
And the father was very violent towards Paula, who was not his biological child. The mother participated, the mother went from that home to living with someone, getting pregnant again, and he died before the child was even born of a heroin overdose. And then she went on to live with Gerald, and there was evidence that Gerald had inappropriate interactions with the girls, and I believe he was also abusive. And while the mother had participated in programs, they said she had not appreciably improved her capacity to meet the emotional and physical needs of her daughters, which became more complex because of everything.
What does that mean? While what you just said, while she had participated in programs, she had not blah, blah, blah. What does that mean?
So you go and they try to train you on how to nurture and interact, and
And you said she had been suffering from battered woman syndrome.
yes, and how to care for your children, how to protect them from further abuse. And she left the programs and didn't change anything because here she was living with Gerald, who I don't know that he actually sexually abused her, but there were that he had sexually abused Phyllis, but there were concerns that he had inappropriate interactions with the girls, and so they said the mother would not be able to protect the girls in the future from their abuse.
But mother had, it sounds like, complied with some or a significant amount of services?
I think a significant amount, yeah. But she had, when they asked her, well, so she
How was
up
it?
to,
Go ahead.
She was up to 6, 7, 8 kids, and she had no realistic plans for how she could take care of these kids, how she could either meet the needs, because now these girls had a lot of psychological damage, and she had no plan for how to meet those needs, nor how to take care of all these children.
Yeah, raises some of the concerns and discussions we had when we did the domestic violence piece. Sad, she tried.
Yeah.
But she herself had too many issues. Children were also getting older and had issues themselves. And she also had made a an argument that DSS, DCF, whatever, really prematurely, hadn't made enough efforts, I guess, to in terms of reunification. So that was one of our arguments as well, but it just in the end wasn't enough. And it goes back to, again, the SJC is a reviewing court, right? Reviewing what the judge below at trial had done, and not sitting again as a second trial judge, making its own determination de novo, but instead reviewing that the court below committed any error of use discretion. Juvenile court judges, as I said before, at the conclusion of these trials, have to be very careful in how they complete, how they draft their findings. They have to have extensive subsidiary findings of fact, rulings of law, upon which their conclusion that children should be adjudicated in need of care protection and possibly termination as well is, warranted. So, yeah. Anybody want to add to that, to Paula? Okay, who wants you to cover Manuel for us? John?
Manuel wanted custody, wanted his grandparents to have custody of him after
So who was Manuel?
he's a child.
Okay.
And DSS already awarded temporary custody to, the court already awarded custody to DSS, and
When you say the court awarded custody to DSS, in what stage of
there was an
the proceedings?
interlocutory relief denied.
I'm sorry, I didn't hear you, John. What?
Manuel was requesting an interlocutory relief by a single justice in this court, and it was denied.
Okay, but then you jumped too far ahead. Go back to when the care and protection case is first filed.
All right.
Because you said something about DCF
All right.
getting custody.
Yeah, they were awarded temporary custody
How? In what hearing?
in the subsection 24 hearing.
Which is what? We talked about it before. What's the 24 hearing?
What is that? I don't know, I'm drawing a blank here.
It's a number.
72 hour.
The 72-hour hearing, okay.
Okay. Okay, so the court refused to allow the grandparents to adopt because of a pending or a prior domestic abuse on the.
Not to adopt, you jumped into.
I'm sorry, award custody.
Okay,
Because of a domestic abuse that the grandfather had prior,
okay, yeah.
and that was the gist of it. But they were saying that they refused to. They refused to award custody after they've already awarded custody.
So wait. 72-hour hearing, and then Manuel goes where? After the first 72-hour hearing, under
To his
section
first
21.
foster home.
He goes to a foster home?
Yeah, after.
Not to grant,
To the maternal grant.
Oh, Mrs. V. That's right.
and Mrs. B is his
Aunt.
aunt?
Yeah.
Okay, so he's there with the aunt, but then,
She was allegedly sexually assaulted Roberta, his sister.
okay, so Manuel's removed from there,
Mhm.
right? And now there's going to be another hearing, right?
Right.
And that other hearing is under what section?
Section 25.
25,
Yeah.
okay? And that's where all the to-do was about, right?
Yeah. And they asked the question whether 25 empowers the judge, upon request of the child, to hold a temporary custody or placement hearing.
Exactly, which is pretty much the same. And in the end, what today they're even called Manuel hearings, that the child, and the parents certainly have this right at a temporary custody hearing. No matter how, first of all, no matter how a case begins, a care and protection case, you're going to have a temporary custody hearing, right? And it could be under 24, because the children were taken on an emergency, or it could be under Section 25. And in both respects, it's a temporary custody hearing where DCF has to show, remember the Robert case, by preponderance of the evidence, that removal, is necessary to protect the child from abuse or neglect. But what's the most important about Manuel, right, is exactly what you just said, John, the right to also have the judge consider placement, consider any nomination by the child or his parents of a relative or other individual to become the temporary legal custodian during the pendency of the care and protection matter. And that piece of it is, so if that becomes an issue in a care and protection case, the courts usually call it, we're going to have a Manuel hearing, which is, again, a placement kind of hearing, and that's the importance of that. Okay? That, as well as the similarities, I guess, between Section 24 and Section 25. Like, when you look at 25, it's just this short little section, but the standard is the same. The standard is the same. Should DCF or somebody get temporary temporary custody of this child who's in danger of abuse or neglect?
Can they do a manual hearing whenever they want? If it's a kid who raises the question of who he wants to be?
No, because remember, the reason for the second hearing was because he was removed.
All right.
Right?
Yeah.
He was removed from his first placement, and so that issue again became, where should this kid be, right? Michael, you want to do Helen?
Sure. So on the adoption of Helen's 1999 case, basically, there was a child that lived with her mother. There was a 51A report because the mother was living with the child in a home that had been raided for drugs a couple of times. When the department came in, they created a service plan for the mother to seek some drug rehab and counseling. Essentially, she had started to do that and stopped doing it. At one point, the daughter was taken into foster care, and the mother was supposed to be able to have visitation. She had sort of started that and then stopped, and then basically fell off the radar from months at a time.
Right, she did.
And so then the department moved to dispense with consent for adoption, and the mother reestablished. She was, seemed to be doing okay again, and then fell off the radar again. And then ultimately, the department was granted the dismissal of the consent for adoption. The mother appealed, said the daughter appealed with her, and they were challenging that the findings weren't exact. The dates were a little off, and then also that they felt that Chapter 119, Section 26 allowed for the mother to request redetermination hearing.
Yep.
And the court basically said that once your consent for adoption has been dispersed with, you're no
That
longer
doesn't apply
entitled to that
anymore.
because
Yep.
it would undermine the statute and it would lead to people constantly delaying the child from moving forward with a new family. It would there'd be constant turmoil and litigation. And then also that the argument about the visitation. So the judge had
Exactly.
ordered that the mother was entitled to visitation, and then that was appealed. And on appeal, they basically said that, the mother didn't have enough of an established relationship with the child to warrant demanding visitation.
So what is the standard for visit? We talked about the standard for stopping visitation when the case is ongoing. Remember the camp protection case, one of those custody of a minor cases? Remember that when that DCF couldn't just suspend visitation during the pendency of the case, right? Because according to service plans, they're supposed to be looking for reunification. Parents have visitation rights all along, et cetera, et cetera. But now we're looking at visitation rights in the context of post-adoption, after a parent's rights have been terminated. So in what context should or can, right, a juvenile court order post-adoption visitation rights? And certainly it wasn't done here, and the SJC affirmed it.
It has to show that it's not going to be detrimental to the child's best interest.
Yeah, exactly. Exactly.
I think they also talked, it might have been another case, but they were talking about how if the adoptive parent consents
That's the last case you guys have, the Lona case, talking about that.
If they
Yep.
consent to it, then that's fine, but
Mhm.
for the courts to demand it, they have to show that it's not harmful to the child.
Exactly. Best interest, again, best interest standard. Okay, thank you. What do we have next? Adoption of Mary, I think? Was Mary your next case?
Mary,
yeah.
Jennifer?
So, JD gave birth to Michael out of wedlock. JD's the father. Then they married the mom, which is RB. No, I lied.
No,
J-
it's not.
JB is the mother, and RB is the father. And then the 51A report was filed due to poor supervision and medical neglect, lack of supervision, and poor judgment. A couple reports were filed, actually. The first one was in 1985. And the second one was
Yeah,
filed
so
in
this was one of those old cases that I talked about.
Right.
Yeah.
The second one was filed in 1988 for the same, under the same basis of poor hygiene, poor supervision, lack of food, filthy living conditions. So at that point, a social worker was assigned to the family. The social worker recommended that the family should have counseling. By November of 1989, there was no progress, so the court adjudicated the kids to be in need of protection and placed them in a foster home. Then in 1991, the father was convicted of assault and battery on Mary. And then on the same day, the mother was found guilty of assault and battery on both children. That's basically it. Michael, obviously both children had severe issues. Michael was found to have extreme difficulty in trusting adults, so he started sexually assaulting the children he lived with in the home.
Mhm.
And Mary had issues, but her foster parents were able to take care of her appropriately.
So if you could put sort of in a nutshell what warranted the unfitness, particularly of the mom, what?
Basically, she couldn't take care of them. She didn't give them proper nutrition. She didn't pay attention to them. She just wasn't really a mom to them at all. So that made her an unfit parent.
Did the court also talk about the investigators' reports?
Yes.
Okay.
They had 3 investigation reports that they found could be used in court. It was proper to use them in court.
To admit them?
Yeah.
Not prejudicial? Okay.
Then there was evidence supporting the finding that the mother was an unfit parent that was also admissible in court. And that was basically it, right?
So, somewhat similar to the point that I raised before about the juvenile court judges really being careful for a number of reasons, not to be overturned on appeal, of course, that to really document the support of their decision that parents are unfit with, detailed findings. And I meant to say this before when Michael was doing the Helen case. 59 findings. Can you just imagine? And that's not even getting to the rulings of law yet. So can you imagine just the plethora of cases that the juvenile courts deal with? I mean, this is just, a case that went to trial. There's, the arraignments of the kids that are charged with delinquency. There's the youth offender, the really serious cases. There's the care and protection cases. There's what used to be called the CHINs, child requiring assistance, at all different, stages. There's the runaways, kids who skip school, kids who were held in lockup over the weekend that some of you have seen on your Monday visits. And then on top of it, besides the judge sitting all day long in these cases, then has to, not only sit in a lengthy trial, but then make all of these detailed findings. Really, not to be, but I think they work harder than some of the other trial judges in the Commonwealth. Thank you, Jennifer. All right, who wants to do the Diane
I
case?
just wanted to make a comment. One thing that sort of stuck out in this case that you've actually talked about, but it was it says, however, when a petition to dispense with parental consent for adoption is filed, the relationship between the parent and the intervening agency acquires an adversary character, ultimately the parent's motivation.
Yes, adversary.
But it's, to me, I think it's way before
Way
that. Like
before
you were
that.
saying that, the moment that these agencies come in and start, making the allegations of abuse, and
Yeah.
it's adversary then.
Yeah. I mean, DCF, even in their regulations, talk about the conflicted goals that they have. One is to, help and assist families, and the other is to protect children. And so many, many, many times, those two goals are at, odds with each other. Exactly. Stephanie, do you want to do that adoption of Diane?
Sure. This one was a little confusing for me because it was kind of hard to tell who the social worker was assigned to, whether it was the mom or the child. But anyway, so the mom is trying to get she's attempting to get her child back. She was seen as unfit. She had histories of getting into fights, and
She had what, I'm sorry?
she had a history of getting into fights. Just
Mm-hmm.
really not a good parent. And so the child was taken based on 51A, and the mother originally, I guess she wanted to consent to an adoption, but I think there was something that she changed her mind.
Was this case, I remember that it was an older case,
It is.
but I don't remember if it was just direct filed in probate court under Chapter 210, or did it start as a care and protection case in the juvenile court?
It started as a care and protection case.
Yeah.
This was 1983, I see.
Yeah, so this was one of the older ones.
Yeah, it's a pretty older case. And upon, they started questioning the mother's challenging that the mother was basically fighting for her rights. The mother argues that the judge improperly admitted the considered testimonies of the social worker and therapist, which should have been excluded in accordance to the statutory privileges, which basically...
Which would have applied to the care and protection case.
Right.
But not to
Right.
the adoption case.
Right.
Yeah.
So they were trying to merge
exactly.
the two, and this is why it's
Yeah.
confusing.
And that's why those earlier cases were absolutely crazy.
Absolutely. But at the end, the case was affirmed, and she still was not able to receive her child because they found no error. It said that there was no error found in this case. The judge found that the mother is currently unfit and unable to assume parental responsibility. So,
All right.
it's unfortunate.
Okay. Wants to do Frederick, who hasn't had a turn yet? Amanda Phillips.
I haven't done it yet, but when I copied it off, I didn't get the beginning of it, so I have some of it.
Okay.
Okay, so this is a 1986 case, I believe. So it's an old one.
Yep.
And they were terminating the parental rights of the parents, and they wanted to appeal this. Parents did, and their attorney brought the appeal, and the probate judge found on January 8th, 1988, by clear and convincing evidence, that the mother and the
Can I
biological...
stop you a second, because you said appeal, but it wasn't the appeal.
Okay.
You had remember, again, the old procedure was you had the care and protection case in juvenile court, and then the adoption case in probate court, right?
Okay, so this is the
Yeah.
adoption case then?
Yeah.
Okay, and
So you had the juvenile case where the case all started, the abuse and neglect of the parents, the judge making findings there, and then the department moving for termination, right, in the probate
Okay.
court. Okay, go ahead.
And then the probate judge did find that by clear and convincing evidence, that the mother and the father were unfit.
And so what were some of the factors that determined they were unfit? And again, these are some of the statutory factors in 210.3.
That's a previous thing that I don't have here. I have that they're trying to determine who should have custody and the care and protection.
But what makes but not only the parents unfit, but that it's in the best interest of the
Yes.
child to be,
Okay, so they're unfit, and therefore it's best interest of the child to have their parental rights terminated and the adoption to proceed.
what was going on there? What did the parents do, not do? Do you remember?
I don't have the beginning of it.
Anybody want to help?
Yeah.
And it's nothing more than some of these factors.
Well, obviously, they weren't taking care of the child.
Lengthy separation between parent and child.
Talk louder, Amanda.
A lengthy separation between parent and child, the growth of emotional ties between parent and child, and a different custodian, and the effect of a forced return of the child to the biological parent are the factors that should be weighed.
Yeah, and that's what I meant when I said that the court in Frederick mentions these factors that were prevalent in the Frederick case, and they also are some of those statutory factors in 210 Section 3. You know, how long has the kid been in foster care or in, some other care of someone else? Has the parent been, visiting? Has the parent complied with, services? Has the child bonded, with the foster or pre-adoptive home and so forth? So basically just more of the same. Now, Bezio v. Patnon is another really landmark, again, case that's not a CMP case, but certainly applicable when we talk about parental rights. And we only need a couple of minutes on that one. Laura, you want to do?
Yeah, so the woman, Bezio, she had one daughter, and then she got married and was pregnant with another, and she had quite a few over the years, significant medical issues. And during those times, she had a friend of hers in Massachusetts have temporary guardianship of her daughters. And this went back and forth for a long time. The mother stayed involved for the most part with the children, and she was very good with them, and she was very attuned to their needs. She was relaxed, her children relaxed, well controlled. She set up a home at one point, and the guardian had her arrested on a warrant for kidnapping, and the children returned to Massachusetts. So, and through this, she had the medical issues, and then she also had checked herself into Stonehouse. She did not suffer from mental disease. It was therapy for support in dealing with the separation from her children. So as time went on, she left her husband and she established a lesbian household. And the court ruled, the lower court, ruled that the children should stay with the guardian. And they said that in deciding the guardian should retain custody, the judge noted that the guardian had provided an excellent home, care for the children. She loves the children, they love her. The children love their natural mother and desire to visit with her, but they regard her, the guardian, as a real mother. It caused great trauma to the children to remove them from a home where they're happy. And so at I think this was an SJC case? Mm-hmm. Yeah. So at the SJC level, they said that the Commonwealth may not attempt to force the breakup of a natural family without an affirmative showing of parental unfitness. And they said that the test of parental fitness or best interest of the child, they're not to be applied to the exclusion of the other. The best test, the critical question is whether the natural parents are currently fit to further the welfare and best interests of their child. And then it said the probate judge made no finding that the mother was currently unfit to further the welfare of her children. And he then also said that they went so far as to say that a lesbian household, the lower judge had said, created an element of instability and would adversely affect the welfare of the children.
Okay, that's what this case was really about. I was waiting for you to get, get to it.
Yeah.
So if you put in a sentence, what this case stands for and how you could use it, to argue if you represented a parent. Well, how would you put it, Laura?
That you have to find that the parent's unfit to further the welfare of the child, not that someone is more fit. And clearly, a lesbian household doesn't make you unfit.
What you said at first was just the general rule that we've been seeing over and over again. But the distinction here is that your lifestyle, A, lifestyle, and B, sexual orientation does not make one unfit. Would certainly be error or abuse of discretion if a court, juvenile court or a probate court judge, uses a factor like that to determine loss of custody or to determine unfitness. It's how the parent relates to the child, right? All the different factors that we've been looking at so far that amount to fitness or unfitness, right? Readiness, capacity, etc., towards the welfare of the child. Lifestyle has nothing to do with it unless the lifestyle somehow affects the welfare of the child or adversely affects the welfare of the child. Old case, but that was the case that really set the standard back then. Let me see, adoption of ARPA.
I have a quick question
Yeah.
about this so we can start. At the very end of this case, it looks like, this has been edited down quite a bit by you.
Yes.
Did we miss like a whole chunk we should have had about the admission of evidence in the Garnett letter report? Because it basically says the father disputed it, but it never says what the court said about it.
I don't remember.
Okay.
Sorry.
Because that kind of, I'm like, I wonder how they.
Yeah, because again, the reason why this is a leading case had to do with, the time in which it was decided, when courts would, come up with decisions like this that had nothing to do with the best interest of the child and the parenting skills. But there may have been other issues that the court dealt with as well. Do we have time for author? Yeah, this is a quick one, actually. Jim? Oh, Jim, Amanda, what?
Arthur, that wasn't his real name. He'd been under care and custody of DCY for most of his life. Most recent petition was brought in 1986 and was contested by both parents. However, they lived apart and had never been married to one another. Arthur actually believed it was no longer feasible to be living with his parents. He had settled into his foster home. He was doing extremely well. School was nearby, and he remained active in recreational life. The two cases were consolidated, and after a 5-day trial, the parents were found to be unfit. Judgment in custody was entered, awarding DSS custody of Arthur. The judge had an in-camera.
How old was Arthur?
14.
Okay.
And he conducted an in-camera interview with him.
Mm-hmm.
And Arthur was present with his lawyer at the time, and he wanted to be adopted by the family, by a family with similar makeup. Although he did remain concerned about his biological parents. And the father objected to this interview. And in essence, the court found that the court stated that because of the delicacy of cases involving the interests of children that may be adverse to that of their parent, the trial judge is not restricted to ordinary modes of trial, but may direct that the child be brought before him and may examine him privately and may also avail himself to affidavits and the like in order to determine or give way to what the child's needs are.
And basically, again, in terms of the standard of review, the judge made, no error, sound discretion. In-camera isn't done all the time, but that was done in this case. Notice that the child was also older, which in one respect you would think would warrant in testifying in open court, but it didn't really have to do with the parents abusing or neglecting him, but it had to do with his preference for adoption, and that's why the case is cited today. I think we have time for gratitude. Amanda, did you want to do gratitude? Or you just volunteering for?
Yeah, I guess so.
What was mother's unfitness, if at all? What was her problem?
I'm taking her meds.
She wasn't taking her
Yeah,
meds? Is that?
She was, I think she went into a program or something, and she was required to take her medication, state level, but she wasn't cooperating and taking the medication. I'm just trying to find the section. Service plans were set up so that the mother could go 1 hour visitation, 1 hour supervised visitation with Greta. She had to follow other requirements, such as taking her medication. I think it was proloxin, a psychiatric medication.
So as Mike just said, she wasn't taking her meds. Is that the reason for termination? Can that be a reason?
I think
for
that, along with something else, the fact that she had violent outbursts and was arrested for violent and explosive behavior. The judge found that the mother was not passive at the visits and did not initiate activities. She usually just sat around smoking cigarettes, talking to the adults, and didn't really show any care for Greta. Serious lack of understanding of the feelings of Greta. Lack of capacity to deal with the feelings of Greta.
So what does all that mean, Amanda?
I think it's factors that go to show that she's unfit as a parent.
Yeah, again, so the judges have to be careful that, as Michael said, she wasn't taking her meds. That in and of itself isn't enough, right? It has to do whether you're, whether you're.
It impairs your
Whether.
ability.
Go ahead.
It has to impair your ability to function as a parent.
Exactly. So it would be a factor in the findings of fact. In and of itself, it's not enough.
Right, and didn't they talk about how the decision wasn't based on just her not taking the medication? That
Exactly.
in the care plan, sometimes it was generally addressed as far as just follow your medical treatment, as
Right.
authorized, recommended by the doctor. In other circumstances, it wasn't in there at all. So that, because the mother was trying to say that was the only reason why you took my kid away was because I'm not taking these meds.
Exactly.
And you have to show, medical necessity that I have to take it. And they said, no, there were a lot of other things going on that, this was just one piece of it.
So let's hold off and we'll do Alona. Remember, we're not meeting this Thursday, so next Tuesday we'll start with Alona, and I think then we have Linus in a small group of cases.
Yeah,
And,
only 5 cases.
Yeah, small group of cases, and what we'll do is I'll talk a little bit about preparing you for the little mock hearing that we'll be doing the following week. Okay, thank you.